2009 session of the Georgia General Assembly approved a piece of legislation called House Bill 251, led to a good bit of discussion and controversy. Georgia School Board Association meeting back last summer had an opportunity to discuss this, and the issue regarding the disenfranchisement not only of board members but also of employees within the school district caused me great concern. This particular measure, I don't believe, was fully debated at the General Assembly. It was added as a provision on the last day or so of the General Assembly regarding eligibility of someone to serve on the school board if they have an employee within certain positions within the school district. That issue ultimately was signed into law by the governor, sent to the Justice Department for approval. And the Justice Department ultimately approved it, and there have since that time been some school board members who have not been able to run for re-election in other parts of the state. It has an impact, obviously, on board elections this time, but also has impact on employees that you hire, where you might have a board member serving that's family member in that community, not only here. I looked at this throughout the summer. I asked for some additional assistance during the fall from Peter Olson, local attorney. I asked him to do some research and looking into whether or not there was, in fact, a constitutional challenge that could take place. We have at least one board member directly impacted, one employee of our school district directly impacted. We have another board member that's indirectly impacted, and certainly a former employee of this district, if she were to decide to come back, who would be impacted. As a result of that, and Peter's analysis, we started looking at what our options were. And one of those options was to, in fact, file federal litigation in the Northern District of Georgia, primarily against the Secretary of State acting in, at that time, now his official capacity as the Superintendent of Elections. My recommendation and my request to you tonight is to authorize us to move forward with that litigation. I have attempted to develop a budget in connection with that item in working with Peter's office to get litigation filed, and the intent was to try to get it filed prior to the opening of the session. It was, in fact, filed last Monday, which was the opening day of the session. A couple of things I want to point out. Number one, I think this affects not only our board members, but it affects our employees as well as future employees of this district who might have a family member serving on this board, whether it's one of you or whether it's somebody else. We know that Kelvin Simmons in Gainesville has already been disenfranchised. He'd been a 16-year board member and was disenfranchised. In fact, he qualified to run for re-election with Gainesville City and was taken off the ballot once this legislation was approved by the Justice Department because he had a family member working at Gainesville City School System, again a 16-year member of the board. A couple of things I want to point out to you. The action does request, in the event that the state of Georgia has violated the constitutional rights of our employees and our board members across this state, that we get reimbursed for our costs in connection with this litigation. I think that's important to note. We also believe that this legislation could generate some activity during this session of the General Assembly that might undo all or portions of this last-minute amendment to House Bill 251 last year. Second to the budget, trying to figure out, because I heard your comments just a minute ago and I've seen the governor's remarks. I was there when they were made. And it's of concern to us what's taking place with public education and what funding is going to be available to you and how that would impact your employees. Trying to be sensitive to that. I think we're looking at something in the vicinity of $15,000 to $17,000 in order to fund this litigation through the stage of the injunction. And then you would have to make a decision whether we proceed any further. If an injunction were denied, then an appeal could rise, and that would be a question where it would come back to you as a board. for further approval. My request of you tonight is to authorize that litigation and authorize the budget in connection with that. I'll be you, not just Matt, not just Kelvin Simmons.
We got to do what's right, and what we're doing is right.
But I would just say finally, some of that anger that people may have, Boyd, should also still be directed towards the legislature, because they have placed us in this position in other school systems around the state, and I think this is a knee-jerk reaction to a situation that happened in a local community somewhere where they weren't able to come to some agreement on how they should run their thing, and that ends up costing everybody because they want to solve a local problem by enacting state legislation, and that, I think we've all seen, never works.
I don't know of a legislator that came to us and asked us what our nepotism policy was. I'll be honest with you. I'm not aware that they came to us before they voted and asked us, what is your nepotism policy of immediate family? And I'm not aware that they. Okay. Any further discussion? Okay. Do I have a motion to pass this? Funding?
So moved.
Second. Any further discussion? All in favor of?